Affirmative action is a policy aimed at addressing past discrimination by giving more opportunities to groups that have been historically disadvantaged. It has been used to promote diversity, help disadvantaged groups succeed, and reduce inequality. However, it is a controversial topic with differing opinions. Supporters believe it promotes equality and representation, while critics argue it can result in reverse discrimination and hinder minority students. In a significant ruling, the Supreme Court declared race-conscious college admissions processes unconstitutional. This video will explain how this decision came about. Affirmative action is a term used to describe policies that aim to promote fairness and equal opportunities in employment and education. It originated in the United States through executive orders signed by President John F. Kennedy and President Lyndon B. Johnson in the 1960s. These orders directed government contractors and employers to ensure that they treat employees fairly without discriminating based on factors like race, religion, sex, or national origin. The Civil Rights Act of 1964 also prohibited discrimination on these grounds. However, it is important to note that these policies did not explicitly authorize giving preferential treatment to specific groups of people. Affirmative action tries to make up for past discrimination and reduce current inequalities. This can be done through things like setting quotas, targeting specific groups in advertisements, providing training, and being more flexible in selecting candidates. Studies have shown that affirmative action had a positive impact in the past, helping more women of different races get better jobs. However, the effect decreased over time. Nonetheless, still becoming a federal contractor increases job opportunities for women and minority groups. Overall, affirmative action is seen as a way to address historical injustices and promote fairness for everyone. In the United States, temporary rules have helped increase the number of black employees over time. Polls indicate that most Americans support affirmative action for women, but opinions differ when it comes to other minority groups. Some argue that affirmative action goes too far and gives preferential treatment, while others believe it's necessary to address past inequalities. Support for affirmative action varies among different groups, with higher support observed among Black Americans compared to white Americans. Overall, people hold different views on affirmative action, but many recognize its importance in promoting diversity in college campuses and workplaces. Affirmative action is a controversial topic that sparks heated arguments. Some people believe it helps achieve equality and lift up groups that have faced discrimination in the past. They argue that specific programs and policies are needed to address historical disadvantages and close racial wealth gaps, benefiting everyone in society. On the other hand, opponents claim that it leads to reverse discrimination, where qualified individuals may be overlooked in favor of less qualified candidates from underrepresented groups. They worry that merit-based selection may be undermined. Views on affirmative action often align with political parties, with Democrats generally supporting it and Republicans opposing it. Different states have different laws regarding affirmative action, showing that opinions on this issue are complex and varied. In the late 1970s, there were legal challenges to affirmative action, and the Supreme Court ruled that quotas couldn't be used, but race could still be considered in admissions decisions. Throughout the 1980s and 1990s, the court put restrictions on race-based affirmative action, citing concerns about reverse discrimination and limiting the use of racial preferences. This led to opposition against affirmative action, and California passed a law in 1996 that banned preferential treatment based on race or sex. Similar laws were proposed in other states, and the Supreme Court upheld the constitutionality of these laws. The court addressed affirmative action in key cases like Grutter and Gratz at the University of Michigan, affirming its constitutionality but setting limits on the use of race as the main factor in admissions decisions. They also upheld a Michigan amendment that banned race-based preferences. In the Fisher case at the University of Texas Austin, the court reviewed and eventually approved an affirmative action program. Critics of affirmative action claim that it hasn't been very helpful for black people who are economically disadvantaged. They argue that prestigious schools like Harvard often admit black students from wealthier families, leading to racial diversity but not addressing the challenges faced by low-income black students. These critics believe that universities should consider both race and economic background in admissions policies to tackle the barriers that poor black students encounter. They think that top institutions tend to focus on recruiting wealthy students instead of addressing broader socioeconomic inequalities. They suggest taking a more inclusive approach that recognizes the impact of class disparities among Black Americans, aiming to provide equal opportunities for everyone. Medical school acceptance rates in the United States show that Black and Hispanic applicants, even with average academic credentials, have higher chances of getting admitted compared to equally qualified Asian and white applicants. This has led to questions about whether there is a form of affirmative discrimination or racial profiling that benefits certain minority groups. The data reveals disparities in acceptance rates based on race and ethnicity, with Black and Hispanic applicants being more likely to get accepted even if their academic credentials are slightly below average, while Asian and white applicants face lower acceptance rates. These findings raise concerns about the fairness and neutrality of admissions policies in medical schools, especially in states where using race as a factor in college admissions is not allowed by law. In 2022, the Supreme Court decided to review two cases that questioned a previous ruling called Grutter v. Bollinger. The people bringing the cases argued that this ruling allowed colleges to discriminate based on race in their admissions process. In June 2023, the court made a decision stating that both Harvard and the University of North Carolina did not follow the rules set by the Grutter case and violated the Equal Protection Clause. This decision essentially means that race-based affirmative action programs in college admissions are no longer allowed in the United States. Here are some quotes from the justices after its decision. Chief Justice John Roberts: "Eliminating racial discrimination means eliminating all of it." Justice Clarence Thomas: "Justice Jackson would replace the Second Founders' vision with an organizing principle based on race. In fact, on her view, almost all of life's outcomes may be unhesitatingly ascribed to race. This lore is not and has never been true. Even in the segregated South where I grew up, individuals were not the sum of their skin color." Justice Ketanji Brown Jackson: "With let them eat cake obliviousness, today, the majority pulls the ripcord and announces colorblindness for all by legal fiat. But deeming race irrelevant in law does not make it so in life. And having so detached itself from this country's actual past and present experiences, the court has now been lured into interfering with the crucial work that UNC and other institutions of higher learning are doing to solve America's real-world problems." Justice Neil Gorsuch: "The words of the Civil Rights Act of 1964 are not like mood rings, they do not change their message from one moment to the next." Thomas: "Justice Sotomayor apparently believes that race-conscious admission programs can somehow increase the chances that members of certain races, Blacks and Hispanics, are admitted without decreasing the chances of admission for members of other races, Asians. This simply defies mathematics." Roberts: "While the dissent would certainly not permit university programs that discriminated against Black and Latino applicants, it is perfectly willing to let the programs here continue. In its view, this court is supposed to tell state actors when they have picked the right races to benefit." Thomas: "After siloing us all into racial castes and pitting those castes against each other, the dissent somehow believes that we will be able at some undefined point to march forward together into some utopian vision." Thomas: while I am painfully aware of the social and economic ravages which have befallen my race and all who suffer discrimination, I hold out enduring hope that this country will live up to its principles so clearly enunciated in the Declaration of Independence and the Constitution of the United States, that all men are created equal, are equal citizens, and must be treated equally before the law. Among many quotes, Justice Thomas and Justice Jackson engaged in a heated debate over the legacy of racism and the use of affirmative action, with Thomas criticizing Jackson's support for the policy and accusing her of perpetuating victimhood among black individuals. Thomas argued that wealth gaps and racial disparities were constitutionally irrelevant, while Jackson emphasized the historical barriers faced by black Americans and the need to address race-linked disparities. Justice Jackson's viewpoint, Justice Thomas said, would keep black people locked into a seemingly perpetual inferior caste. He called that an insult to individual achievement and cancerous to young minds seeking to push through barriers, rather than consign themselves to permanent victimhood. He also wrote that she was drawing on race-based stereotypes, when, in reality, all racial groups are heterogeneous, and blacks are no exception, encompassing Northerners and Southerners, rich and poor, and recent immigrants and descendants of slaves. By articulating her black and white world, literally, he added, Justice Jackson ignored the experiences of other groups, including Chinese immigrants, descendants of Holocaust survivors and those who came to the United States from Ireland, fleeing famine. Justice Jackson pushed back sharply against Justice Thomas. Gulf-sized race-based gaps exist with respect to the health, wealth, and well-being of American citizens, she wrote. Although those disparities emerged years ago, she added, ignoring that history would be foolish because those inequities have indisputably been passed down to the present day through the generations. Their differing viewpoints reflected a clash over the impact of racism and the best approach to achieve equality. If colleges and universities are no longer allowed to consider race when admitting students, it could affect the number of minority graduates entering the job market. This raises concerns about diversity in the workforce. Ken Oliver suggests that without race-based admissions, fewer students of color may get into universities, which could pose challenges for the future job market. However, he believes that companies can find other ways to promote diversity, like recruiting from historically black colleges and universities or areas with large minority populations. By doing so, companies can still create diverse workforces that reflect American society without facing negative consequences. Recent events have shown how important affirmative action is in promoting diversity and fairness, especially for marginalized groups who face economic difficulties. Even though the Supreme Court has set limits on the use of race in college admissions, it is still allowed when it relates to an applicant's personal qualities or special talents. This decision affects a significant number of high school graduates each year, including Black, Asian, Hispanic, and white students. It is crucial for us to better understand how equality and affirmative action are connected and find smart solutions to address this matter.
Thank you for watching this video. If you found this enjoyable, kindly consider liking and subscribing.